Judges in the Fifth Circuit Court of Appeals are currently debating the future of the abortion pill and whether the dangerous drug will remain on the market. Alliance Defending Freedom, representing the plaintiffs in the case, argue that the FDA did not properly evaluate the safety of Mifepristone, the first drug in a chemical abortion, before putting it on the market in 2000. Fifth Circuit Judge Matthew Kacsmaryk ruled in favor of the plaintiffs in April and suspended the FDA's approval of the abortion pill. The Supreme Court temporarily blocked Kacsmaryk's decision, returning the case back to the Fifth Circuit. Mifepristone remains available while Fifth Circuit judges re-examine the case. Joining me now from ADF's senior counsel is Erin Hawley. She is also the vice president of ADF's Center for Life and Regulatory Practice. Erin, thanks so much for joining me. Can you give us an update on the latest from the Fifth Circuit? We know that now a panel of 3 judges on that court is reviewing the case. Talk to me about the gravity of it.
Absolutely. Well, as you mentioned, this case is very important because it concerns the FDA's approval and continual deregulation of the chemical abortion drug. Today, women can get this drug without ever seeing a doctor, without being evaluated for contraindications like ectopic pregnancies or finding out how far along gestationally they are. It can lead to serious life-threatening injuries, and that's why a district court judge put the entire chemical abortion regime on ice. The Fifth Circuit recently heard argument, and they seem to really take on board the dangers associated with this drug, especially when it's mailed out without any of the safeguards that the FDA itself once said were necessary for the drug's safe use.
The risk is just immeasurable that women are being put in here. Erin, we're going to continue to track that, but shifting gears a bit, I want to get your thoughts from a legal perspective. Almost a year out from the overturning of Roe, in Dobbs, the Supreme Court has set a standard that every state can legislate on abortion as they see fit, but pro-life laws are still being challenged by pro-abortion groups across the country. Could any of these cases make their way to the Supreme Court in this post-Roe world anytime soon?
Absolutely. And to take just a minute to pause it and to note how momentous it is that we actually are in a post-Roe world, a post-Dobbs world, which promises to the American people that the states and their elected representatives can protect life. And Alliance Defending Freedom is fighting in a number of states, I think about a dozen, to uphold these good pro-life laws, to allow states to enact these provisions that finally are able to protect life. And there's a number of challenges winding through, but we are hopeful that the federal courts will indeed come through on the promise of Dobbs and allow states to protect life finally.
And as you well know, abortion isn't the only cultural evil that we're fighting right now. Could you speak to some of the other high priority cases that our viewers should be following?
Absolutely. So there are a number of cases involving parental rights when we're talking about, what children are taught in schools, whether a school district might be able to transition a child without their parents knowing at all. These sorts of fundamental issues that are important to parents and families all over the country, and decisions in which parents should absolutely be involved are some of the cases. There are a number of women's sports cases in which biological males are being allowed to compete and take competitive opportunities away from females. In addition, the 303 Creative case, we expect a decision any day now from the United States Supreme Court, and we are hoping that the court will affirm that free speech is a right for everyone, including religious believers. As your viewers may remember, Lori Smith is the plaintiff in that case, and Lori Smith serves everyone. She simply declines to create certain websites based on the messages they convey.
Right.
So we're certainly hoping the court upholds that right.
Well, thank you for keeping track of all of these things and raising the red flag on these important cultural issues. I have one more question before I let you go. We talked recently on this show about the potential for babies to be protected under the Equal Protection Clause of the 14th Amendment on the federal level. Litigation-wise, is there anything that could happen in the coming months that would prompt the Supreme Court to weigh in on that front? I know Congressman Doug Lamborn just introduced a resolution this week in Congress calling for the recognition of unborn children to be protected under the 14th Amendment. So I'd love to get your thoughts on this.
So I'm not aware of any pending case that could bring that to the Supreme Court's attention imminently. However, it is an argument that's being made in the lower courts. A lot of research, of course, there's the Robbie George and George Finnis brief that was filed in the Dobbs case, sort of laying out this argument that the 14th Amendment, if it protects corporations, then surely it also protects unborn children.
Sure.
But there's a lot of work in the lower courts, I think, that needs to be done first, and that groundwork that needs to be laid.
Well, it's good to know that those conversations are being had on the lower level, and I appreciate your expertise on that and on everything we've discussed. Thanks so much for joining us, Erin Hawley of Alliance Defending Freedom.
Thanks for having me.